Namaste to you all. In the previous clip regarding Unit 2, we have discussed about the objectives of Industrial Disputes Act, and then we also discussed about the definitions, some of the definitions like appropriate government, what is appropriate government, under section 2A, under section 2B, what is award, under section 2C, BB, what is average pay, and then under section 2C, let me tell you, under section under section 2AA, okay, sorry, 2AA, average pay, and this is appropriate government, and 2B is award, and 2C is closure, and 2J it is industry, and 2K industrial dispute. I think we have discussed the definition on appropriate government under section 2A, 2AA average pay, then 2B award, then 2C closure, then 2J industry. What is by industry? And then industrial dispute. What is the last one being industrial dispute? What is the meaning of industrial dispute? How it is different from individual dispute? An industrial dispute is a dispute or difference between employer and employer, employer and employee, employee and employee, workmen and workmen, employer and employer, employer and employee, employer and workmen, workmen and workmen. This is what? Connected with employment, non-employment, terms of employment, conditions of employment are known as industrial dispute. How it is different from individual dispute? Normally, the difference or dispute between employer, workman, employer, employee, and workman, if the dispute is between employer and individual employee, then that is called individual dispute. But when this individual dispute, when this individual grievance of an individual employee or workman, if it is supported by other employees or the group, then it will turn out to be, it will change its color to that of industrial dispute. Understand that? From industrial dispute to, from individual dispute to that of industrial dispute. What is the meaning of industrial dispute under section 2K? It's a dispute between employer and employer, employer and workman, employer and employee, workman and workman, connected with employment, non-employment, terms of employment, conditions of employment. But when the same is between employer and individual workman, then it is called individual dispute. But this individual dispute can become industrial dispute when his cause or her cause, individual grievance, individual workman's cause is supported by a group of workmen or by their trade union. It becomes industrial dispute. And there is a dispute, of course. There is a difference between industrial dispute and individual dispute. Like when the dispute is collective, when the dispute is between employer and a group, substantial part of employees, it is called industrial, connected with the employment, non-employment, etc. It is industrial dispute. When the dispute is between employer and individual workman or individual employee, connected with the employment, non-employment, terms of employment, conditions of employment, it is called individual dispute. An individual dispute can become industrial dispute when it is sponsored or supported by the group or the trade union. For disposing of individual dispute, there is time limit is prescribed under the section 10 of Industrial Disputes Act. That is 3 months normally, okay, ordinarily. But for industrial dispute, of course, not that it is unstipulated, but the time stipulation is not that shorter one. Let us now proceed to section 2N. What is public utility service? Section 2N defines public utility service. And what is that public utility service? Any industry which is carrying on any activity so as to be termed as public utility services, under section 2 clause N, they have clearly defined what amounts to public utility service as such. They are the following. Namely, when the activity on the part of the industry becomes or establishment becomes a public utility service under section 2 clause N, it is very much defined. These are the activities on the part of the establishment amounts to public utility, service. There are in fact 6 or 7 activities carried on by the establishment amounting to public utility service, and they are namely: 1. Railway. Under section 2 clause N they are defined. One is that any activity carried on by the railway service or any transport service, it is called a public utility service. Like we have got our state road transport corporations or airport corporations. Then you have got railway corporation. They are all public utility service, whether carriage of passengers on road and or by air, etc. Then any service in connection with the working of any major port or dock. Okay, any service or any work in connection with the major port or dock. Next, any section of industrial establishment on the working of which the safety of the establishment is very much concerned, then that also. Any postal, telegraph or telephone service. Any industry which supplies water, light, water. Any industry which supplies water, light, power to the public. Any system of public sanitation or conservancy. Then any industry specified in the first schedule to the Industrial Disputes Act. These are all amounting to public utility service. And why the relevance of this definition? What is that? We may quote giving railway, postal, any establishment focused on safety of the establishment. Then any carriage service by road, air, or then you have got any activity connected with the power, light, water, etc. These amounts to public utility service. And there are also the other activities as specified in the schedule to the Industrial Disputes Act. First schedule, whatever activity is to be termed as a public utility service. And why? What is the relevance of this definition? The relevance of this definition is that an activity so as to be termed as public utility service, then such activity must be meant for public benefit. And whatever activities Schedule 1 attached to the Industrial Disputes Act clearly lays down those activities, and they are all for the public benefit. And where any establishment engaged in itself with the public utility service, then that particular establishment shall not commit a breach of the same. I mean to say, there are certain precautions for you either to go on strike or lockout, etc., etc. It is not that easy. In breach of the provisions or procedure prescribed under section 22, you cannot go on strike. So if you are in the public utility service, then under section 22 of the Industrial Disputes Act, you should be going on strike according to the procedure prescribed therein. Right. That's the 11th. Then 2Q. What 2Q defines strike? What is by strike? Cessation of the work, or collective stoppage of the work, or refusal to do the work by a body of workmen employed in the industry, or under a common understanding by all the persons employed in the industry, and their refusal must be to continue to do the work or to accept, the refusal must be to accept the work or to continue to do the employment. That's it. And what is the reason? Reasons must be some industrial dispute. Why you are striking? What are the different forms of strike, etc. But let me tell you, so 2Q defines strike. It means stoppage, cessation, cessation of work. CESSATION, cessation of work or collective stoppage of work by a body of workmen employed in the industry, or under a concerted refusal or common understanding of any number of the persons employed in the industry, must be, their common understanding or concerted refusal must be to continue to do the work or to accept the employment given. Why? It must be in consequence of some industrial dispute. Okay, that is where strike is defined. Normally, features of the strike must be, I will tell you when we proceed to strike and lockout in detail in section 22 and 23. And section 22 clause 3K defines layoff. What is by layoff? in order to, layoff means temporary. It's a temporary inability of the employer to keep the establishment fully working on account of some of the reasons like shortage of coal, raw material, power. 1, 2, breakdown of machinery. 3, accumulation of stock. 4, natural calamity. Or 5, any other reasons connected with any of the above. Any other reasons other than the, above as stated. So why employer proceeds to, layoff? Layoff means keeping you aside, not refusing to give you work. And why this refusal or keeping you aside from work? Why you are off from the work on the day? You are to report to the work at the appointed time every day as usual. But unfortunately, work could not be given. Why? The establishment is flooded. So it is one of the reasons like natural calamity. Why? Because there is accumulation of stock. And whatever product or the service that we have manufactured, it is not finding market in the. It is not finding market in the market. It is not finding currency. When it is not finding the business, when it is not finding the market, then what is the fun of? What is the very purpose of carrying out the industrial activity when its producers are not finding a sufficient market? There is accumulation only. Employees, of course, will challenge this layoff. Employees will, of course, challenge. But though employee may challenge, though workmen may challenge, employer is given the provisions by law to overcome such losses, to reduce, to mitigate such losses that may be happening on account of intermittent power supply, on account of shortage of power, raw material, coal, accumulation of stock, or it can also be called lack of marketing, lack of demand, then the breakdown of machinery, then the natural calamity. When any of these reasons surfaces, when any of these reasons persists, then is it possible? No. Then justifiably law has given the right to the employer to lay off your services, on account of that. This is what the definition of layoff. Temporary inability on the part of the employer to give employment to any number of the workmen whose name is borne in the muster roll of the industrial establishment, and it must be on account of any of the following reasons. 1, shortage of power, coal, raw materials. 2, breakdown of machinery. 3, lack of demands, or we can call it as accumulation of stock as well. 4th, natural calamity. And 5th one, any other reasons other than the above. Then we proceed to define retrenchment. What is retrenchment? When the inability on the part of the employer is not temporary but continuing one, you have resorted to layoff. Layoff can be resorted to in a calendar year for maximum period of 45 days. And what are the conditions for layoff? And when laid off workmen will not be entitled to compensation, we will discuss in the next when we take up layoff and retrenchment. But right now, in a calendar year, he could be laid off for 45 days with the compensation. And 46th day, no question of compensation, no question of 46th day. But if the employer's problem continues, then in which case employer may have to go for one, that is retrenchment. When he is unable to keep the establishment fully working for a consistently longer period, then even to retain, he cannot go for a layoff because that is ended. Then in which case, to keep the establishment, so as to save the establishment, so as to keep the establishment fully working, because he finds at this rate, if all the employees are retained, then no work could be given. There is no demand. The market demands have not been improved. When market demands have not been improved, then it's a better option. We have observed temporarily to sustain you in the employment, we have resorted to layoff. But even with those measures, the establishment is unable to keep you, and on account of its continued losses. So when there is a continued losses, employers, it is a inability on the part of the. He will proceed to retrench, terminate you from the service, terminating you from the service by way of retrenchment. There are terminations in several other ways, but this is a termination by way of retrenchment. Why? When the employer is unable to keep his establishment fully working for when he is unable to keep the establishment fully working for a recognizable period of time, for a quite length of time, for a longer time, then law has given him the right. What is that right? Law will not, ask, no, employer, you cannot terminate, you should keep giving the employment. If no employment could be given, you keep giving, you keep sustaining them, keep employing them in the employment. That's it. There is no question of terminating them from the service. You should sustain them. You should, keep them in the service at your, peril. At your loss. What is this? You cannot, law cannot be that harsh. For having created the employment and given employment opportunities to many, when the employment is not doing well, when the employment is running in losses for a considerable period of time, you still want the employer to, sustain the employees in the employment at losses. No. And law has recognized in such cases, when the employer is unable to keep the establishment fully working for a considerable amount of time, then employer is permitted to go for retrenchment on the principle last come, first go. Whoever lastly appointed, they will be the first one to go out. And in case, why? Because I find I cannot be, say for example, I have got 200 employees. I cannot be, running the establishment or industry with the 200 right now. At this rate, on account of the continued losses, I think I can sustain only about, 100, not beyond. So the last 100 men, they will be terminated from the employment on account of retrenchment. Termination, relationship. See, that's the difference. In case of layoff, employer-employee relation will be intact. Only work is not given because you are required to be present at the establishment at the appointed hour every day, and whether work is givable, whether the problem is solved, any of those reasons exist. If the problem has not been solved due to the shortage of coal, raw material, breakdown of machinery, lack of demand and all, employer will say that you are laid off. Even if the employer doesn't say anything within 2 hours of so present, then it is deemed layoff, something like that. He can proceed for layoff. But when the losses are continuing one, then he considers that I don't need a 200 workforce. So how many number of workmen or employees I can continue the employment? He will consider that I can continue at 100 and not 200. So he will, terminate the 100 workmen whom he finds surplus on the principle last come, first go, and termination will happen. But section 25 F should be complied with. There are 2 sections procedure. What is the section 25F says? In order to terminate the service on the ground of retrenchment on account of continued losses, then employer shall be serving 1 month notice in writing indicating the reason thereof to the concerned workmen or employees. And in case if you are unable to give that notice, at least pay 1 month in lieu of notice, 1 month wages along with compensation. If you have been in the service for the 10 years or 15 years or 20 years, for every year of complete service you have to pay them 15 days of average pay. Average pay to be gathered how? We have discussed in the definition. Average of the wages, if you are a monthly paid during the past 3 months, if you are a weekly paid during the past 4 weeks, if you are a daily paid during the past 12 working days, full working days, and if you are a daily paid wager, then during the past 12 full working days, how much you have earned, total it, and then divide by 12, you will find the average pay for a day. And in case of retrenchment compensation, it is 15 days of average wages payable for every year of completed service. How many years you have done? I have done 12. Then 15 days for every such 12 years of completed service. It is 180 days of retrenchment compensation, and a notice shall also be served on the appropriate government. That you will find in section 25F. But what I said is that when the inability of the employer is continuing one, is unable to keep the establishment fully working with the present workforce, then he may reduce the workforce, because he considers at this rate the workforce is that there is surplus in the workforce. Therefore, on the ground of last come first go principle, you will terminate the employees or workmen from the employment on account of by way of retrenchment. But it must be connected with the loss therefore. But if there is any re-employment opportunity, after reducing the surplus, you carried on and then slowly you recovered, and then you think of think of inducting of any employees. Invite must be given to those retrenched employees. Taking or leaving, it is their choice, but you must give this reinstatement. Section 25FF dealing with the 25FFF, it seems. Okay, I mean section 25FFF providing for. Okay, but of course I cannot be that very clear, but I will tell you 25F, 25FF, 25FFF, 25H and 25G. These 5 provisions are dealing with the retrenchment along with the section 200. Okay, right. Then section 2S. What is workmen? What is workmen? Workmen means any person employed. Section 2 clause S of the Industrial Disputes Act defines workmen. It defines section workmen. Workmen means any person employed to do skilled, semi-skilled, unskilled, manual, clerical, supervisory, whether for hire or reward, whether the terms of employment is expressed or implied, and it includes such persons whose dismissal, discharge or retrenchment, or whose discharge or dismissal or retrenchment led to the industrial dispute, but will not include the following: those who are in the employed in the Army Act, Air Force Act, Navy Act, those who are employed in the police service, those who are employed in the managerial or administrative category, though earning monthly wages of 10,300 or more, they will not be included as the workmen. And there are categories of workmen. Okay, what do you mean by workmen? Workmen means any person employed in the industry to do skilled, semi-skilled, unskilled, manual, supervisory or clerical in nature, whether for hire or reward, whether the terms of employment is expressed or implied, and it includes the persons who are discharged, dismissed and retrenched, or whose discharge or dismissal or retrenchment led to the industrial dispute, but will not include the following: those persons who are employed in the Indian Army Act, Air Force Act, Navy Act, next Indian Police Act, next who are in the managerial or administrative category earning monthly wages of 10,300 or odd. Right? That is, there are different categories of workmen. Okay. Bangalore Water Supply Sewerage Board versus Rajappa, a case is there. Rajappa was in the technical wing of the Bangalore Water Supply Sewerage Board. There was some dispute connected with the conditions of employment between him and the management. He raised a dispute, and this particular case study is discussed when we defined the industry, as well as this case study is being discussed in whether he is a workman. It was held Rajappa is a workman, and it was held BWSSB is an industry. What do you mean by industry? Industry, section 2J we defined earlier. Industry is a systematic activity carried on with the cooperation between employer and employee for the purpose of production, supply, distribution of goods and services with a view to satisfy human wants and wishes, not being purely religious or spiritual, whether or not any money has been invested in the carrying on that activity, whether or not the purpose of that activity is to make gain or profit, and it includes the activity carried on by the dock labor board, but will not include agricultural, hospital, dispensaries, education institutions, sovereign functions of the government, club, provided number of the persons employed is more than 10, profession, any activity carried on by them will not be called industry unless the in the profession or club number of the persons employed to carry on their activity is more than 10. And there are categories of workmen like permanent workmen, casual workmen, temporary workmen, budly workmen, protected workmen. Regular workmen are called permanent. Temporary workmen whose terms of employment, their continuation in the employment is not, the length of time to which they will be continuing is not clear, therefore temporary, not fixed, therefore temporary. Then you have got budly, when the regular workmen, in case if they go on leave like sickness leave or maternity leave, etc., medical leave, then probably what happens, in their place, they will go on that leave, but work should go on, in their place someone will come having the similar skill, they will call it Badli workmen. When the regular workman comes back, this Badli workman will go. Okay, then we have got protected workmen. Who is protected workman? Protected workman status is given to 1%. Normally, ordinarily it is given to 1% of the total working populations, subject to the maximum of 5. And this protected workman status is given to office bearers of the registered trade union who are employees in your establishment, subject to the maximum of 5 at the rate of 1% for every 100. You understand? In your establishment, you may have about 3,000 employees. It means whether there will be for every 100 one each means it will become 30. No. Subject to the maximum of 5. Subject to the maximum of 5, and at the rate of 1%, this protected workman status is given. Employer will give this protected workman status only to office bearers of the trade union, subject to this limitation. What is that limitation? 1% of the total workforce, subject to the maximum of 5. Okay, then we will discuss, in the end, we will define that settlement. What is by settlement? You have already seen, award means interim or final determination of an industrial dispute by labor court, industrial tribunal, national tribunal or arbitration proceedings under section 10A. Labor court is 7. 7A is industrial tribunal, national tribunal is 7B. Okay. But what is settlement? Settlement may be of two types. 2 clause P. Settlement may be of two types. What is that settlement? Settlement means an agreement arrived at for the purpose of resolving industrial dispute, either existing or apprehended. Either it might have been arrived at in the course of the proceedings or otherwise than in the course of the proceedings. Settlement may be arrived at either in the course of the proceedings or otherwise than in the course of the proceedings. Even if the proceeding is pending before any labor court, conciliation officer, board of conciliation, industrial tribunal, national tribunal or arbitration, wherever the dispute either existing form or apprehended form, wherever it is referred for settlement or adjudication, it is pending before the authority. Correct? Even if it is pending, it will not prevent the parties from settle the dispute by way of settlement, mutual settlement. It is by agreement. You can settle the dispute. Where even if the case is pending before any of these authorities, you can still. But till what time? When the authority has pronounced the award, then there is no question of settlement. You are bound by the award. Okay. When it has submitted the report to the government, no question. You have to wait for the award. But when the authority is yet to submit its report, then any time before the award or any time before they submit the settlement, the report, the parties can settle. Though the case is pending, going on, even there you can resolve it by settlement. So that's what I mean by settlement. Settlement of two types. One, it can be arrived at. An agreement to resolve the dispute between the parties can be arrived at either at any stage before the award, either during the course of the proceedings, or settlement may also be arrived at even without the course of any proceedings. Settlement may be arrived at in the course of the proceedings, or settlement may be arrived at otherwise than in the course of the proceedings. These are the two where settlement could be arrived at. And what is that settlement? Settlement is the formula for resolving the industrial dispute between the parties as such under section. Then you have got lockout. What is by lockout? Strike we have defined. Lockout under section. Strike we have defined into 2Q. Lockout 2L. What is by lockout? Temporary suspension of the employment. Temporary closure of the establishment for the purpose of bringing pressure or exerting pressure on the employees. Lockout is temporary suspension of the place of employment, temporary closure of the place of employment, temporary closure of the business with a view to exert pressure on the employees so as to make them resume the work, so as to make them to come back to the work with the same, or that depends. Your objective is to bring pressure on them. They may be either resorting, they may be on strike, or they may be about to go for strike, or they may be they might have placed the demands and they are about to go on strike, or they are already in strike. Now in retaliation or in apprehension of that, what you will do? You will lock out, close, temporary closure of the business, temporary suspension of the place of employment. Why? So as to exert pressure on the employees, so as to make them resume the work, come back to the work. That is what you are. And what are the features of strike or lockout? We will discuss now. Okay, but only after the mechanism. What all the so therefore our discussion on this definition part ends. Our discussion on this definition part ends. And in the next clip we will have to proceed to the various authorities constituted under the Industrial Disputes Act 1947 or apprehended. And in that we have discussed in the previous clip regarding the various authorities under ID Act 1947. We have discussed with reference to the same, we have discussed about what are the authorities, what is the objective of these authorities or mechanism provided. It's a mechanism that you have provided under the Industrial Disputes Act for resolving the industrial dispute, either apprehended or industrial dispute is of two forms, namely either apprehensive dispute or actual dispute. And when it happens, then there should be a sincere effort to resolve the same. If you resolve in the apprehensive stage, that is fine. If you resolve in the actual stage of a dispute, it is also fine. But there must be honest effort towards the same to resolve the crisis, right? And we have discussed in the previous class about works committee, about of course these are the mechanism provided: works committee, conciliation officer, board of conciliation, court of inquiry, labor court, then IT, Industrial Tribunal, then National Tribunal, then grievance settlement agency or grievance redressal agency, and then grievance redressal agency rather, GRA, and then there is one more called arbitration. See, under section 3 works committee we have discussed that. Under section 4 conciliation officer we have discussed that. Under section 5 board of conciliation we have also discussed that. Under section 6 court of inquiry we have discussed that. And we are to now continue our discussion from labor court under section 7. What is it, labor court? Labor court will comprise of, labor court is established normally at the district level to resolve any dispute existing or apprehended in respect to the matters contained in schedule. As I said in the beginning, there are 5 schedules attached to the Industrial Disputes Act. There are 5 schedules attached to the Industrial Disputes Act. What are they? Namely, Schedule 1 dealing with what activities will amount to public utility service. Schedule 2, what all the matters in respect of which dispute exists could be referred to labor court. Schedule 3, what all the matters in respect of which dispute exists could be referred to Industrial Tribunal. Schedule 4, what all the matters in respect of which service conditions could be changed. Whether change in the service conditions could be affected in respect to the matters. It could be affected in respect to the matters contained in the 4th schedule. Schedule 3 is Industrial Tribunal, the matters with respect to which either industrial dispute existing or apprehended, then it should be referred to the Industrial Tribunal. And Schedule 4 speaks about what all the matters in respect of which dispute exists could be referred to. Schedule 4 deals with what all those matters, usually such matters are with respect to the conditions of employment. And with respect to the matters contained in Schedule 4, whether employer can bring about a change in the service conditions. Oh, definitely. But by complying with the procedure contained in section 9A. And then Schedule 5. What activity on the part of the employer will amount to unfair trade practice? What activity on the part of the employee or workman will amount to unfair labor practice? This is discussed in Schedule 5. Unfair trade practice and unfair labor practice. When and all, what conduct on the part of the employer, what conduct on the part of the employee becomes unfair trade practice, unfair labor practice. They are being defined in Schedule 5 as such. But now, labor code. What all matters that can be, in respect of which dispute existing or apprehended could be referred to labor court. As I said, it could be referred to the labor court when the dispute is with reference to section, when the dispute is with reference to, schedule 2 as such. With reference to the schedule 2, the matters provided in respect of which dispute existing or apprehended, the matters provided in the second schedule, that is what the jurisdiction of the labor court. Labor court, where it is appointed, the constitution of the labor court is the authority of the state government. The state government, by notification in the official gazette, constitute one or more labor court for the purpose of adjudicating upon the disputes connected with any of the matters contained in the second schedule. And the labor court will be presided over by a presiding officer. Normally, he will be picked from any of these qualifications. What is that qualification for a person to be, for a person to be appointed as a presiding officer in the labor court? He is or has been the judge of the High Court. He must have held a judicial office in India for not less than 7 years. He is or he has for a period of not less than 3 years been a district judge or additional district judge. You got it? He is or has been the judge of a High Court. He has held a judicial office as a district judge or additional district judge for a period of 3 years. Not less than 3 years. Okay. Then he has held a judicial office in India for a period of 7 years, not less than 7 years. Or he has been a regional labor commissioner, joint labor commissioner for a period of 10 years. Or he has been a presiding officer of a labor court constituted under the Provincial Act or State Act for a period of 5 years. Any of these qualifications is present in any person, then that person could be eligible to be appointed as the presiding officer of the labor court. What is the jurisdiction of the labor court? The jurisdiction of the labor court is to resolve the disputes pertaining to the matters, industrial dispute existing or apprehended in respect to the matters contained in Schedule 2. What all those matters? Adjudication of industrial dispute relating to any matter specified in the second schedule are 1. The propriety or legality of a standing order passed by the employer under the Industrial Employment Standing Order Act 1946. Standing orders are those which deals with a set of rules which every employer and employee are to adhere to or comply with. Set of rules in respect to the matters contained in the schedule to the standing orders are known as standing orders. Standing Order Act 1946 contains a schedule, and that schedule contains several matters, maybe wage, maybe holiday, maybe working hours, etc., etc. In respect of which you have to frame the standing order, Mr. Employer. You have to frame the rules and you have to get it approved by the certifying authority. The set of rules framed by the employer in respect to the matters contained in the schedule to the Standing Orders Act is known as standing order. And these standing orders becomes binding once it is certified by the certifying officer under the Standing Order Act. Now, why I am giving you this is that when the employer has made the standing order, then it may be challenged. The propriety or legality of any order passed by the employer under the Industrial Employment Standing Orders Act. 1. The application and interpretation of the standing order if there is any dispute. 2. The discharge or dismissal of the workmen, including the reinstatement or grant of relief to the person wrongfully dismissed. 3. Withdrawal of any customary concession or privilege, that may be. Then legality or otherwise, illegality or otherwise of strike or lockout or any other matters other than those specified in the third schedule. Any other matter but other than those specified in the third schedule. But let me also tell you, apart from these, that is it says the propriety or legality of any order passed by the employer under the Industrial Standing Orders Act. The interpretation and the application of standing orders, the discharge dismissal of the workmen, including reinstatement or grant of relief, etc. Then withdrawal of any customary concession or privilege, then illegality or otherwise of strike or lockout, etc. Or any other matter other than those contained in the third schedule. In respect of these matters, if there is an industrial dispute existing or apprehended, then it could be referred to the labor court. But remember, even if the matter is in the third schedule, if the number of the persons affected by the industrial dispute is less than 100, then that can also be referred to that can also be referred to the labor court. Remember, usually in respect of any matter contained in the third schedule, if the industrial dispute is existing or apprehended, then the jurisdiction will be that of the industrial tribunal. But if the number of the persons affected by the dispute is less than 100, then it could also be referred to the labor court as such. Okay. Then jurisdiction of the labor court is limited. What all the restrictions upon the jurisdiction of the labor court? If at all a question is asked, you have to write this plus this jurisdiction of the labor court to resolve the dispute either existing or apprehended with reference to the matters contained in second schedule is limited. By whom? The jurisdiction of the labor court is restricted by in the following four modes. One, restrictions imposed under the restrictions contained in the ID Act, restrictions contained in any other industrial legislation, restrictions contained in the order of reference made by the government, and restrictions imposed by whom? One, restrictions imposed under the Industrial Disputes Act, restrictions imposed under the other industrial legislations, restrictions imposed under the order of reference, and restriction imposed by statutes, other statutes, not labor statutes. Okay, these are the restrictions upon the jurisdiction. So remember, under section 7, labor court has a jurisdiction, but its jurisdiction is limited. Its jurisdiction is contained under the following. One is that the jurisdiction of the labor court is restricted as per the, the jurisdiction of the labor court is subjected to the restrictions imposed. There are restrictions upon the jurisdiction of the labor court, and these restrictions may be imposed either under the Industrial Disputes Act or under the other industrial legislations, or under the order of reference of the appropriate government for reference to the industrial dispute to the labor court. Remember, labor court jurisdiction commences when the dispute either existing or apprehended, when the dispute is referred by the appropriate government to it, and the appropriate government will refer it by an order of reference, and when the appropriate government has referred it, then that order of reference itself is a limitation. So jurisdiction of the labor court is subject to the restrictions contained in the order of reference, and subject to the restriction contained in the statute as such. That's what about labor court. And then we proceed to industrial tribunal. The state government by notification the state government by notification in the official gazette may constitute industrial tribunal. An industrial tribunal will be presided over by a presiding officer. He is or has been the judge of the High Court and nothing else. And its jurisdiction is with reference to the matters contained in as far as the industrial tribunal is concerned, a tribunal shall consist of one person only, appointed by the appropriate government, possessing any of the following qualifications. He is or has been the judge of the High Court. That's what normally the procedure we do. He is or has been the additional district judge or district judge for a period of not less than 3 years. And out of this, the presiding officer will be usually appointed. What is the jurisdiction of the industrial tribunal? Industrial tribunal's jurisdiction is with reference to the matters contained in the third schedule. What all those matters will be contained? The matters with reference to the third schedule will contain, one, hours of work, leave, privileges, immunities. Withdrawal of privileges and customary concessions with respect to this, leave, wages, overtime allowances, and then rationalization, then rules of discipline, then dismissal, discharge, etc., or disciplinary action. So there are about 12 to 13 matters contained in Schedule 3, in respect of which, if any dispute, either existing form or representative form, if at all it is there, either actual dispute or representative dispute, then it could be referred to by the appropriate government to the industrial tribunal. What are the various that we will discuss when we discuss about section 10 as such. Then what dispute can be referred to National Tribunal? Any dispute can be referred to National Tribunal. An industrial dispute, either existing or apprehended. There are 4 conditions for reference to the dispute to National Tribunal under section 7b. Under section 7a, it is Industrial Tribunal. When the dispute is existing or apprehended in respect of a matter contained in the Schedule 3, then the appropriate government, by passing an order in writing for making the reference to the said dispute to the Industrial Tribunal under section 7a, provided such a dispute must be either existing or apprehended, such a dispute must be with reference to the matters contained in the 3rd schedule. When, under what circumstances under section 7b, the central government, don't say appropriate government now, when the dispute is to be referred to the National Tribunal, then the government, appropriate government is always central government, union government. When the central government is of the opinion that there is a dispute, there are 4 conditions to be present for reference to the dispute to National Tribunal. 1. There must be industrial dispute existing or apprehended. 2. That dispute is involving questions of national importance. 3. That dispute is either affecting the interest of 2 or more states. And 4. The government may also, when any of these conditions are present, when there is a dispute, especially the first 2, the later 2 is alternative. For what is the first 2? There must be industrial dispute existing or apprehended, and that industrial dispute either involves the questions of national importance, or affecting the interest of 2 or more states, or is a fit case to be disposed of by the National Tribunal. Then central government will pass an order in writing for the reference thereof to the National Tribunal. You understand? When the central government may pass an order for reference or dispute to National Tribunal, first of all, one condition is common to all, that is when the dispute is existing or apprehended. And second, third, fourth, any of them prevails, the central government. Second, what is that? National importance, involves the questions of national importance. Or third is that when the dispute is affecting the interest 2 or more states. And fourth is that it is a fit case to be referred. There is one thing under section 10 clause 6, even when the dispute is pending before the labor court, the central government can still transfer it from labor court to National Tribunal. When it is transferred, the proceedings before the labor court stand suspended, stayed, right? That is where. And under section 9c to grievance redressal agency, where the number of employees employed in the industrial establishment is 50 or more, where the number of the employees employed in the workmen employed in the industry is 50 or more, then for every 20 or for every 20 persons, 20 or more persons, there shall be constituted a grievance redressal machinery, grievance redressal agency for every 20. Where the number of the persons employed therein is 50 or more, in every establishment, there shall be constituted a grievance redressal for every 20 workers or employees. It's a responsibility on the part of the employer. And such grievance redressal committee will comprise of equal number of representatives representing both employer and employees. When I say employee, it includes the term workman. And the minimum number of the representation in equal numbers is 1 each, or maximum could be 3 each. So therefore, its a minimum number of membership could be either 2 and maximum could be 6. And who will preside over this grievance redressal? It is on rotation basis. Normally, it will be if it is firstly the employer side, employer representative will be the chairman. Next year, in a rotation basis, next year it will be the employee side, one person will become the chairman. And ultimately, the report will have to be submitted when the dispute is referred to the such a grievance. How many numbers? I said for every 20 workmen, you need to appoint grievance redressal machinery. When appointed, you conduct the proceedings. Employer will refer the dispute to the grievance redressal machinery. Employer will refer the grievance or the dispute to the either existing or apprehended, whatever. Whenever there is any difference, whenever there is any grievance, then employer will refer the grievance to the grievance redressal agency, grievance redressal mechanism comprising of minimum 1 each, maximum 3 each. Okay, and if there are women, that means even a woman should be given representation in the grievance redressal machinery as such. Okay, there should be also women representatives in the grievance redressal machinery, provided women employees must be there in the establishment, otherwise no need of it. Okay, 1, 2. Who will refer the grievance to the grievance redressal agency under section 9C? Employer. Once after referred, within 1 month, you must complete the grievance redressal process and submit the report to the employer, who will be the decision maker. What action will be taken against the, what action will be taken in respect of the report submitted by the grievance redressal authority? The grievance redressal machinery comprising of equal number of representatives there, they are required to complete the proceedings, grievance proceedings within the redressal proceedings within 1 month. And upon completion of the same, they may report, they will report to the employer. It's the employer who is going to take action on the basis of the report submitted by the grievance redressal machinery, grievance redressal agency. And if you are not happy with the action taken by the employer, you may appeal to the the grievance redressal agency will take when the employer has referred the dispute to the grievance redressal agency, grievance redressal agency is required to complete the proceedings and take action on that. If any of them are not happy with the action taken by the grievance redressal machinery, they may appeal to the employer. So therefore, this grievance redressal machinery, in a way, is very weak. The faith in respect to the grievance redressal machinery is very, is not very strong. It's very, very weak. Reason, it gives an edge to the employer in respect of any matters which are in disputes. As such, this grievance redressal machinery may not be relied upon by the worker side as such. Though the final authority as an appellate authority, employer is sitting. I know that in the grievance redressal machinery, if 1 year is employer's representative, another year on rotation basis employee's representative will be there. But against the decision of the grievance redressal agency, employer will be sitting as an appellate body. Therefore, decision is final. Actually speaking, it will give an edge to the employer in reference to the regulation is concerned. In reference to regulation of the relationship is concerned. Then under section 10A and 11 to 15. So far we have discussed about the authorities. Under section 10, that to the Labour Court Industrial Tribunal, who appoints a conciliation officer, who appoints a chairman of the board, who appoints a court of inquiry, inquiring authority, who appoints a presiding officer of the Labour Court Industrial Tribunal, etc. The government, appropriate government, Okay. What is its role under section 10? The appropriate government has to refer the dispute to any of these authorities for resolution, for adjudication or settlement of industrial dispute existing or apprehended. Under section 10, the appropriate government exercises this power. We have got various clauses under section 10 as well. The appropriate government, when it is getting the information that there is a dispute existing or apprehended, when the appropriate government is informed by both the parties or one of the party, or when the appropriate government gets the knowledge on its own, then appropriate government may, after framing a good opinion, after framing an opinion in good faith, after framing an opinion bona fide, the appropriate government may pass an order for reference of the disputes to Labour Court or conciliation, whoever. It may appoint a conciliation officer for conciliation. It may appoint a chairman, it may refer the dispute to board of conciliation by appointing a chairman. It may appoint a court of inquiry to investigate, to collect information, report regarding the dispute from the investigating officer, inquiring officer, to get the report and then decide what to do, whether to refer to the Labour Court Tribunal or whether to appoint a conciliation officer like that. Or it may refer to the Labour Court, it is up to it. It may refer to the Industrial Tribunal, National Tribunal. But in case of National Tribunal, appropriate government which passes the order of reference for reference of dispute to National Tribunal is central government. In any other case, appropriate government, right? What are the various rules pertaining to reference to the dispute to appropriate government? The various rules pertaining to reference to the disputes to the appropriate authority by the appropriate government are contained in section 10. They are 1. We will now discuss with each one of them. When the appropriate government is informed, when the appropriate government is brought to its notice that there is a dispute existing or apprehended, either by the party thereto or any other party or on its own, when the appropriate government gets knowledge from the parties or any other party or on its own, then it may, in good faith, pass an order in writing after framing an opinion for reference thereof. Under section 10.1, to whom? As I said, to the conciliation officer, board of conciliation, court of inquiry, labor court, IT, okay, IT, and yes, this is what section 10 clause 1A dealing with it can pass an order for reference. The central government pass an order for reference to the industrial dispute existing or apprehended to national tribunal when it involves a question, such industrial dispute involves a questions of national importance, etc. Then section 10 clause 2, the appropriate government should ensure that the parties applying for reference of the industrial dispute to any of the authorities for adjudication or settlement, whether they are representing jointly or severally, you must contain in the order. The parties are applying to you for reference of the dispute for adjudication or settlement. Whether they are applying jointly or severally, you have to make. And while doing so, they must fix the time limit. The appropriate government must also fix the time limit to the authority within which they are to complete the proceedings. And if it is individual dispute, such a time limit cannot be more than 3 months. And these are all when the dispute is existing or apprehended, or when the dispute is in respect of a matter relevant or connected to the industrial dispute, it may be, it may appoint a court of inquiry for inquiring into the said dispute. When the dispute is with reference to matters relevant or connected to the dispute, it may refer the dispute to board of conciliation for promoting the conciliation thereof. When the dispute is with reference to the matters contained in second schedule, it may refer the dispute by framing an opinion in writing, pass an order for reference of dispute to pass an order for referring the dispute to labor court. When the dispute is with reference to matters contained in the third schedule, it may refer to the industrial tribunal. When the dispute is, that is what? Section 10.1. 10.1a, refer the dispute to national tribunal. Central government by passing an order in writing may refer the dispute to national tribunal when the dispute is industrial dispute existing or apprehended, when it is involving the questions of national importance, or when it is affecting the interest of two or more states, or when the central government finds that it is a good case, a fit case to be decided by the industrial tribunal, national tribunal, it may pass an order for reference of that dispute to national tribunal. Since it involves who may? The central government. Since questions of national importance or interest of two or more states are affected, obviously central government is the central government, appropriate government, it will pass an order for. Section 10.2, it is to verify whether parties are applying jointly or severally. Then one more, while referring so, it may confine the time limit within which you are to finish off your proceedings. And then one more, if it is industrial dispute, then it may confine 3 months. Then during the pendency of the proceedings, no question of continuing with the strike or lockout, no question of beginning a strike or lockout. Then if the presiding officer of the labor court or industrial tribunal or any, if the authority finds board of conciliation 2 months time, court of inquiry 6 months time, labor court or national tribunal or whatever, when the time limit for the presiding authority is given for completing the proceedings, if the time limit is not enough, then the presiding authority may make an application to the government for extension of the time limit so as to complete the proceedings. It may do so. Then you have got section 10 clause 3 continuation, there is no question of strike or lockout. Pendency, no question of strike or lockout. Then if any new point, the appropriate government, while passing the order of reference, under section 10, they have passed and the matter is before the labor court, for example. right now the appropriate government gets the knowledge that, there is one more or some more points that should have been included in the order, but that is not included. Now what to do? When those points are not covered in the order of reference, then you may pass an order for including that also, and when you have passed an order for inclusion of those points, then the said authority to whom it is referred in earlier, the said authority must include them, the new points, and then continue with the adjudicatory proceedings. It may also be possible sometimes when the dispute is already pending, when the dispute is already referred and it is in the course of adjudication or settlement, whatever, but then appropriate government either on its own or by the parties, if it comes to knowledge that, this industrial dispute which is already referred for adjudication or settlement is affecting some more establishments, but those establishments are not figured in there in the order, those establishments are not named. So what appropriate government can do? Appropriate government can pass an order for inclusion of those other establishments affected by the industrial disputes, for it to be included within the ambit of adjudication. Then when it has passed, then the authority before whom the case is pending, it should go by this order again and include those establishments within the ambit of the disputes and proceed with the adjudication as such. As I told you last one, when the dispute is pending before the before the labor court, the appropriate government is state government, but when the national government, central government decides that that particular case is fit to be disposed of by the national tribunal, it may transfer the case and refer it to the national tribunal, who may? The central government. When it is done, then proceedings before the labor court is stopped, stayed, right? These are all the requirement. In other words, section 10 speaks about what all the powers of the appropriate government, the power of the appropriate government to make the reference to the disputes. Very important from the examination point of view. Section 10. Section 10A, arbitration. The appropriate government, the parties, under section 10A, this is another machinery where the parties to the dispute may, by their mutual agreement, the parties to the disputes may, by their mutual agreement, refer the dispute to arbitration by appointing an arbitrator or arbitrators. What are the conditions for reference to the disputes to arbitration under section 10A? 1. There must be industrial dispute existing or apprehended. There must be industrial dispute either existing or apprehended. 2. The dispute must be existing in the industry within the meaning of section 2J. 3. The parties must have entered into an agreement for reference to the dispute to arbitrator or arbitrators. 4. The parties must have obtained the consent of such arbitrator or arbitrators for acting as arbitrator or arbitrators. And 5. The arbitrators also should have agreed to act as arbitrator or arbitrators. And where there are two arbitrators in even numbers, if they are divided in their findings, then it will be referred to a third arbitrator. Again, the third arbitrator will be appointed by consensus. So this is the way you can get the dispute resolved by arbitration proceedings. Arbitration proceedings where you may follow the some of the civil court powers arbitration, but you will be trying to mediate in negotiate conciliation so as to arrive at some sort of consensus with reference to the the measures for resolving the industrial dispute either existing or apprehended. Then under section 11 you will find the procedures, but I will brief. When the dispute is referred by the appropriate government to any of these authorities, what authorities are expected to do? Authorities can follow the procedure prescribed. Let me tell you, you are to make entry and start your proceedings in respect of the matter referred to you, and you are a public servant within the meaning of IPC, presiding officer, and your proceedings are civil code proceedings within the meaning of a civil procedure code. That means you can administer the oath, you can examine the person upon administration of oath, you can issue summons for the appearance of the parties to the dispute as witness, or you can issue summons for the production of documents. You can appoint accessors having the expert knowledge in the field to assist you in the course of adjudication. You can appoint one or more persons expert in the field as accessors to assist you in the completion of the proceedings. You can determine who is to pay the cost of the proceedings, by whom it is to be paid, what amount to be paid, to whom it is to be paid, etc. You can decide. And all these provisions are there, proceedings are there under section 11, and it is your duty, Mr. Authority, when the dispute is referred to you, to commence the proceedings, conduct the proceedings, and complete the proceedings. The date on which you will commence the proceedings, as soon as possible the dispute is referred, you should commence the proceedings. And when you commence the proceedings, you will start exercising the civil court powers, like admission of the case, examination upon administering oath, issuing a summons for production of documents. In case if you want to appoint experts to assist you in the field, yes, you can appoint. All those powers are available. And finally, you should complete the proceedings and submit the award or findings to the appropriate government. Okay. Then award and settlement is there. What is award? Award is an interim or final determination of industrial dispute by the Labour Court, Industrial Tribunal, National Tribunal, or arbitration proceedings. What is the period of commencement of the award? Award will come into force when the findings are submitted by the Labour Court or Industrial Tribunal, etc., to the appropriate government. The appropriate government is expected to publish that findings within 1 month from the date of the receipt. And if it is published within 1 month from the date of its receipt, when it is published, it becomes award. Normally, award is in operation for a period of 1 year. It could be extended to 3 years by the appropriate government, no doubt by a notification. Normally, award is in operation for a period of 1 year. And it could be modified, and application for modification shall be made within 90 days from the date of publication. Application could be made by employer or employees, parties to the proceedings. Application may be filed for modification of the award. When the application for modification of the award is made, then the appropriate government will place it on the table of the legislature. If it is central government, means on the table of the parliament. The appropriate government, the parties, if you are interested to apply for modification of the award, you may do so within 90 days from the date of its publication. And when it is made, then within 15 days, it has to table it. It has to table it and get it modified. Whether they are modified or not, when it is returned, the appropriate government will publish it in the same, in the form in which it has been sent back to them by the their legislature, right? Upon whom it is binding? Upon the parties to the dispute, their representatives, on the employers. Yes. Then when it will commence? Okay, it will commence. Award will come into operation from the date on which it is published. It will remain in operation for a period of 1 year unless it is extended. Okay, that is regarding award. What is regarding settlement? What is settlement? We have defined in section 2 clause P. A settlement will be in operation for a period of 6 months. A settlement may be arrived at either in the course of the proceedings anytime before the award, or a settlement may be arrived at even otherwise than in the course of the proceedings. Correct? That way you can differentiate. Then we move lastly to strike and lockout before we proceed to layoff and retrenchment.